Hello friends, in the series on the income tax cases, today we will discuss the case of Southern Ispat and Energy Limited versus Union of India and others. This case has been reported in 459 ITR at page number 328 and the matter has been decided by Chhattisgarh High Court and the date of the judgment is 8th July 2022. Friends, the purpose of discussing this case is that can the assessee go into the writ petition on the ground that the approval given by the commissioner for issuing notice under section 148 is without den, has been given in a perfunctory manner, the reasons recorded by the assessing officer do not contain the signature and date on which the reasons have been recorded. Can all these things can be agitated by the assessee into a writ petition? In income tax proceedings, most of the writ petitions of the assessee are dismissed on the ground that the assessee do have effective and efficacious remedy in the form of CIT appeals, ITAT appeals, High Court and Supreme Court. So on these grounds, generally these type of writ petitions are not accepted by the High Courts. The question arises that when these writ petitions are rejected on the ground that the assessee has alternative and efficacious remedy, so whether the assessee in actual do have the effective and efficacious remedy. If the additions are made and the assessee chooses to go into the appeal, that is the first appeal, CIT appeal, then nowadays the situation is that since 3 years the notices from the CIT appeal are not coming for fixing the date of the case of the assessee. When the assessee submits the submissions, the remand reports are taken from the assessing officers. The assessing officer do not take the heed to reply to those remand reports in time. In the meantime, the assessing officer do pressure for depositing 20% and in some cases they take very extreme steps in the form of attaching the property of the assessee, taking the and attaching the bank accounts of the assessee, and the whole business of the assessee collapses in a number of cases. And due to faceless regime, the assessee is not able to keep all the points before the CIT appeal also, because everything cannot be explained in the form of written submissions. And if the personal hearing are given through the virtual mode, in those cases, generally those hearings are practically for the ritual, for the formality, and the assessee do not gain anything out of that. Or you can say that as on date, the CIT appeal is basically a dormant authority which is not giving any decisions. So in these type of situations, when the appeals are pending for 3-4 years and the interest is accumulating for the assessee, the demand is raising daily in the form of increased interest, whether it can be said that the assessee do have alternative and efficacious remedy. If the government comes out with some policies for the disposal of the appeals in a set period of time, only in those cases it can be safely assumed that the assessee has efficacious and alternative remedy. But when the procedures are not followed, the principles of natural justice are not kept in mind, the approvals are given without den. It is now a settled law more or less that anything without den is not valid. So when the assessee is coming out with some notices on which the den is not there, so if in those type of situations also the assessee will be pushed into the normal proceedings, then it will be a very awkward situation for the businessman and he will be more involved in this type of litigation process than doing his business, and it can ultimately affect the revenue of the government. So serious note should be taken of this thing, that the appellate authority should be increased they should give their decision in time. That should be time bound. Only in that case it can be assumed that there is alternative and effectuous remedy. But in this case, the court dismissed the writ petition of the assessee on the ground that it is a matter of fact that whether the approval has been given in a perfunctory manner, whether DIN is not there, whether it is manual or computerized. So all these things should be taken care by the CIT appeal, or you have to follow the due process, and the High Court dismissed the writ. At the end of this video, once again I am repeating the name of the case. The name of the case is Southern Ispat and Energy Limited versus Union of India and others, and this case has been reported in 459 ITR at page number 328, and the matter has been decided by Chhattisgarh High Court, and the date of the judgment is 8th July 2022. Thank you, friends.